Imagine this. You get pulled over on your way home. It starts like a normal traffic stop. License, registration, insurance. Then the officer notices your phone lighting up on the passenger seat. A message preview flashes across the screen. The officer asks, "Whose phone is that? You say it's yours?" Then comes the question a lot of people are not ready for. Mind if I take a look? That is the moment where a lot of people accidentally give away privacy they thought the Constitution already protected. Because most people assume one of two things. Either they think police can never look through a phone without a warrant, or they think police can always do it if you've been stopped or arrested. Both ideas are too simple. And if you get this wrong in real life, the mistake can follow you for a long time. So here's the straight answer up front. In the United States, police generally need a warrant to search the digital contents of your phone, but that is not the end of the story. There are important exceptions. There are practical workarounds police may use. There are situations where the rules change, and there are a few words ordinary people say every day that can quietly turn a protected phone into a searchable phone. By the end of this, you'll understand the general rule, the biggest exceptions, the most common mistakes, and the practical takeaway you should remember if this ever happens to you. Start with the basic principle. Your phone is not just another object in your pocket. It's not like a wallet, a cigarette pack, or a set of keys. A modern phone can hold years of texts, photos, videos, search history, banking apps, health information, location trails, private notes, work files, contact lists, and conversations with family, doctors, lawyers, and employers. In plain English, it is less like a container and more like a map of your life. That difference matters because the Fourth Amendment is supposed to protect people against unreasonable searches and seizures. Usually, if the government wants to search private stuff, it needs a warrant backed by probable cause. And in 2014, the Supreme Court made it very clear that this principle applies in a major way to cell phones. The key case is Riley v. California. That case changed how courts talk about phone searches. The Supreme Court said police generally must get a warrant before searching digital information on a cell phone seized from someone who has been arrested. That ruling is a huge reason you hear lawyers and civil liberties groups say your phone gets special protection. But notice the word generally. That word does a lot of work. Because Riley did not say police can never touch your phone. It did not say they can never seize it. And it did not erase every exception to the warrant requirement. What it said is that the old rule allowing officers to search items on an arrested person does not automatically let them dig through the digital contents of a phone. That means arrest alone is usually not enough. And that leads to one of the biggest misconceptions people have. A lot of people think, if I'm arrested, they can just go through my phone anyway. That is not the general rule anymore. Police may be able to take possession of the phone while they secure the scene and seek a warrant. They may be able to make sure it does not become a weapon or immediately destroy evidence. But scrolling through your messages, photos, emails, or app data is a different step that usually requires judicial approval. Here's where many people get confused, though. They hear police need a warrant and think the safest move is to start arguing on the roadside. That is not the lesson. The better lesson is understanding the difference between refusing consent and physically resisting. Those are not the same thing. If an officer asks, "Can I look through your phone?" and you say yes, the warrant issue can disappear fast. Consent is one of the biggest exceptions in search law, and courts do not require police to warn you that you have a right to refuse. That surprises a lot of people. You do not get Miranda-style magic words before a consent search. If your consent is considered voluntary under the circumstances, that can make the search lawful even if no warrant existed 5 seconds earlier. That means some of the most dangerous words in a police encounter are not dramatic words. They are casual words. Sure, go ahead. I've got nothing to hide. It's fine. People say things like that because they want to seem cooperative. Sometimes they say it because they feel pressure. Sometimes they think refusing will make them look guilty. But the Constitution does not work on vibes. If you agree, you may have just opened the door yourself. Now, that does not mean every so-called consent is valid. If police coerce someone or falsely claim they already have the legal right to search, the consent question can get more complicated. Courts look at the total circumstances. But from a practical point of view, the safest thing for ordinary people to understand is simple. If you clearly consent, you may be giving police permission they did not otherwise have. So what if you do not consent? Does that end it? Not necessarily. It just means the police may have to rely on some other legal basis. One of those bases is exigent circumstances. That is a legal phrase people hear all the time, but rarely get explained in normal English. It basically means an emergency, a real fact-specific emergency, not mere convenience, not we were curious. The Supreme Court in Riley itself pointed out that emergencies can still justify a warrantless phone search in some cases. Think about an imagined scenario where officers reasonably believe a kidnapped child's location might be on the phone right now, or a suspect is actively warning an accomplice about an imminent attack. In situations like that, courts may allow immediate action without waiting for a warrant. The idea is that when life, safety, or the immediate preservation of critical evidence is truly at stake, the law does not always require officers to sit still and lose the chance to stop the harm. But this is important. Emergency is not a blank check. Courts are supposed to look closely at whether the facts really justified acting without a warrant. And as technology has changed, some older arguments about fragile electronic evidence have become less automatic. Law enforcement manuals have long discussed the danger of remote wiping or destruction of digital evidence, but even then, seizing the phone to preserve it is not always the same thing as fully searching it on the spot. That distinction matters more than most people realize. Police may be able to seize a phone and keep it secure while they apply for a warrant. That is different from immediately opening apps, reading chats, and browsing photos. In other words, they took my phone and they lawfully searched everything on it are not the same sentence. There's another detail people often overlook. The law may protect the contents of your phone, but it does not always protect you from revealing things in plain sight. If your lock screen shows message previews, names, or notifications, it can create its own problems. A phone that lights up with "delete those pics now" is not the same as a dark phone with nothing visible. Privacy sometimes starts before the encounter ever happens, with how your phone is configured day to day. And that opens up a practical question viewers naturally ask next. What about unlocking the phone? Can police force you to type the passcode or use your face or fingerprint? This is where the answer becomes less clean. The law on compelled unlocking is more unsettled than many people think. Different courts have treated passcodes, fingerprints, and face unlock in different ways, and the legal arguments often involve the Fifth Amendment, not just the Fourth. Some courts have treated compelled unlocking as a testimonial act that can reveal your knowledge and control over the device. Other courts, especially in different factual settings, have been more willing to allow compelled decryption or disclosure. So if someone says, "The police can always force you to unlock your phone," that is too broad. If someone says, "They can never force it," that is too broad too. The honest answer is that this area can depend heavily on jurisdiction, the exact facts, and whether police are seeking a passcode, a biometric unlock, or some other form of access. That uncertainty is exactly why people should not talk themselves into confident myths based on social media clips. Now let's deal with another misconception. A lot of people think phone searches are only a criminal law issue after an arrest. But that is not always how the story unfolds. Suppose police do not even need to physically search your phone first. Suppose instead they want records connected to it. Your location data, for example. In Carpenter v. United States, the Supreme Court said the government generally must get a warrant before obtaining historical cell site location information from a wireless carrier. That matters because it shows the privacy issue is bigger than whatever is stored on the glass rectangle in your hand. Sometimes the real trail is with the provider, not just the device. So even if officers never swipe through your photo app in front of you, phone-related privacy can still become a major legal issue behind the scenes through warrants, court orders, or provider records. That is why the best question is not only, can they open my phone right now? The better question is, what phone-related data are they trying to get, from whom, and under what authority? Skill, but that still leaves the everyday scenario most people worry about, a stop on the street, at home, or during an arrest. Here is the most practical framework I can give you. First, if police ask for consent, understand that you can refuse, calmly, clearly, without arguing the case on the sidewalk. Something simple like, "I do not consent to a search of my phone," communicates the point. You're not required to explain why. You're not required to debate constitutional law in real time, and refusing consent is not the same thing as obstructing. Second, do not physically interfere. Do not yank the phone away. Do not start deleting things. Do not smash it, hide it, or try to outsmart the situation with theatrical moves. Once law enforcement is lawfully engaging with you, trying to destroy evidence or escalate physically can create a much worse situation fast. Third, remember that silence and consent are different. Handing over the phone, unlocking it for the officer, or saying "go ahead" can change the legal picture. A lot of people lose this issue not because police had an ironclad exception, but because the person casually cooperated past the point they meant to. Now, here's where the rules can shift in a big way. The border. If you are entering or leaving the United States, border search rules are different from an ordinary street encounter. Customs and Border Protection says officers may search travelers' electronic devices at the border. Under CBP policy, a basic search can be done with or without suspicion, and an advanced search, meaning a search using external equipment to copy or analyze contents, requires reasonable suspicion or national security concern plus supervisory approval. That is a very different framework from the ordinary phone plus arrest equals get a warrant first rule people learn from Riley. This does not mean every traveler should panic. CBP's own numbers show electronic device searches affect a tiny fraction of overall international travelers. But tiny fraction does not mean zero. And the border is one of the clearest examples of why police need a warrant for my phone is not a universal sentence you can carry into every context unchanged. That also means if you mostly know this issue from domestic police encounter videos, you may be applying the wrong rule to airports and ports of entry. Border law is its own world in many ways, and viewers should understand that before travel, not during secondary inspection. There's another group of people who need to pay extra attention to exceptions. People on probation, parole, or some other supervised status. Courts have long recognized that supervision conditions can reduce a person's expectation of privacy. That does not erase all rights. It does mean the analysis may not look the same as it would for an ordinary citizen with no supervision conditions. In some cases, search terms tied to probation or community supervision can dramatically affect what officers may do. That is why the same phone, with the same apps in the same pocket, can raise different legal questions depending on the owner's legal status. People often want one universal answer because it feels safer. But constitutional law is full of context, and context changes outcomes. Now let's talk about work phones, because this catches people off guard too. If the phone or device belongs to your employer, your privacy expectations may be weaker than you think. Courts have recognized that employees often do not have the same privacy expectation in company-owned devices that they might have in a purely personal device. That does not mean your boss and the police are the same thing. They are not. But if your work phone, company laptop, or employer-owned messaging system is involved, the privacy analysis can get much messier. The more the device belongs to the company and is used for company business, the less comfortable you should feel, assuming it carries the same protection as your personal locked phone. That raises a practical habit worth thinking about. A lot of people mix everything together now. Family photos, private chats, banking apps, work emails, health records, and side business messages all on one or two devices. The legal system does not care how emotionally blended your digital life feels. It looks at ownership, consent, control, status, and context. That means the same person can have strong privacy arguments about one phone and weaker ones about another. So what happens if police do get a warrant? And the conversation changes from can they search to how far can they search? A warrant is not supposed to be unlimited permission to rummage forever through every bite of your digital life for any reason at all. Warrants are supposed to be tied to probable cause and describe what officers are looking for. In the digital world, that can still become broad and messy in practice because phones hold so much information in one place. But the existence of a warrant matters. It means a judge has authorized a search based on a stated showing, and challenges often shift to scope, particularity, timing, and how the search was executed. That may sound technical, but the takeaway is simple. They have a warrant does not automatically mean they can do literally anything. It does mean the legal fight, if there is one, is usually no longer about the absence of judicial approval. And here is something else ordinary viewers should keep in mind. Rights are strongest when you know how to use them calmly, not dramatically. Calmly. A lot of people imagine constitutional rights as a speech, a perfect line, a movie scene. But in real life, it is often much more ordinary. It is staying polite, not volunteering extra information, not consenting when you do not want to consent, not lying, not resisting, and understanding that the roadside is rarely the place where a legal dispute gets fully resolved. That is especially important because people often talk themselves into bad decisions for emotional reasons. They want to prove innocence right now. They think cooperation will end the encounter faster. They worry refusal will look bad. They get embarrassed, they panic, they try to explain. They start unlocking the device to show one text, one photo, one receipt, and before they know it, the encounter has expanded far beyond what they intended. And that expansion is a real theme in digital searches. Permission given for one thing can lead to exposure of many other things. A phone is dense, it is layered. A single unlocked screen can lead to message threads, cloud backups, photo metadata, app notifications, call logs, and location trails. That is why courts treat phones differently from old school containers. The amount of life inside them is enormous. So does refusing consent make you look guilty? Maybe some officers will say it does. Maybe some people around you will think it does. But rights are not reserved for people who look relaxed while using them. The law does not require you to make the government's job easier by waiving your privacy. The key is how you exercise the right. Calm refusal is very different from confrontation. At this point, some viewers are probably wondering, okay, but what should I actually remember if this happens fast? Remember this. The general rule is that police usually need a warrant to search the digital contents of your phone, even if they arrest you. But police may still be able to seize the phone while seeking that warrant. If you consent, you may remove the warrant issue yourself. A real emergency can change the analysis. The border is different. Probation, parole, and supervision can change the analysis. Employer-owned devices can change the analysis. Phone-related records held by a provider can raise separate issues from the device itself, and unlocking the phone can involve additional legal questions that are not settled the same way everywhere. That is a lot. But once you hear it in plain English, the pattern starts to make sense. The law is trying to balance two things at the same time. The government's interest in investigating crime and the individual's interest in not carrying a complete searchable archive of their life in their pocket for the state to open on demand. The modern phone forces that balance into the open, in a way older cases never had to face. And that is really the deeper lesson here. This topic is not just about phones. It is about how old constitutional rules adapt to technology that knows more about you than most people in your life do. So if you ever face that question in real life, mind if I take a look? The most important thing is not sounding clever. It is understanding what that question really means. It may sound casual. Legally, it can be huge. One last imagined scenario. Suppose two people are stopped in very similar situations. Same kind of officer, same kind of suspicion, same kind of phone. The first person nervously unlocks the device and says, "Sure, I've got nothing to hide." The second person stays calm and says, "I do not consent to a search of my phone." Those two encounters may look almost identical from the outside. Legally, they can become very different stories. That is why knowing this before you need it matters. Not because it guarantees a certain outcome. Not because every state, officer, judge, or fact pattern is the same. And not because general education replaces legal advice from a real lawyer in a real case. It doesn't. It matters because a lot of people lose privacy not when a court rejects their rights, but when they give those rights away in the first minute without realizing it. And if there is one sentence worth remembering from all of this, it is this. Your phone is highly protected, but it is not magically untouchable. The Constitution gives you real protection here. The Supreme Court has said so in powerful terms. But the protection works inside a system full of exceptions, context, and human decisions. That means your best defense is not a slogan. It is understanding the rule, recognizing the exceptions, and staying calm enough not to make the situation worse. If this ever happens to you, think clearly. Distinguish a request from a command. Distinguish seizure from search. Distinguish cooperation from consent. And remember that in digital privacy, law, small moments can have very big consequences.